failure to protect assets for the next generation. I would ask you, what keeps you up at night, at least when it comes to your assets? I'm sure there's a lot we're all stressed these days. The world is crazy. But are you worried about your child getting divorced in the future? Have they already gotten a divorce? Are you worried about your child getting sued? Are you worried about how estate taxes might affect future generations, like your grandkids or even great-grandkids for all you worked for? Do you have a child or a grandchild with a disability or special needs? Do you have a child or a grandchild with substance abuse issues, or they're not good with money? They're prone to getting manipulated by bad actors. Leaving assets directly to your child is often a mistake. In fact, I would say it's usually a mistake given all the tools that we have to protect assets. Kids with a disability or with special needs, very, very crucial that you do not leave assets directly to them. Instead, you need to create a special needs trust for their benefit. This is a big part of our practice. It is basically a legal structure that provides a lifelong legal and financial safety net. It's a way for you to leave assets for the benefit of a child with a disability in a way that doesn't interfere with their eligibility for government benefits. It ensures that someone or some entity that you trust will oversee these assets for your child for the rest of their life. And it prevents them from getting manipulated and losing all that money. It can provide this extraordinary lifelong financial safety net that can still allow your loved one or your child to receive needs-based government benefits like SSI or Medi-Cal. And it is the most powerful tool available if you have a child, a grandchild, a niece, a nephew who you want to support after you're gone. My father, Michael Gilfix, and I wrote the Special Needs Trust Creation and Management Guide. It's available on Amazon. Make sure you're working with an expert. You need to set up a special needs trust for your child. Now, if you already have one, if this is an issue in your family, you need to review it every few years because you need to make sure that this is up to date. One of the toughest toughest decisions for a special needs trust is who's going to be the trustee of this, who's going to oversee these assets for your loved one. And that can change over time, right? You have to think very long into the future. But a failure to set this up ahead of time can result in the loss of public benefits. It might result in your loved one having to go to court to get a new one created for them, or someone else creating a different type of trust for them. It can just be a big mess. So now, what if there's not a disability, but you're worried about a child or grandchild who has issues managing money, or they have substance abuse issues, or they are subject to bad influences? Do not leave assets directly to that child. There are many solutions for different estate planning structures where you can empower someone you trust to oversee assets for those, I guess you could say, problem kids, where you can still support them, but you can be sure that money doesn't disappear, that it's not taken by bad parties, it's not used for drugs or partying. This is another critical mistake people make. They know there's a problem, but they don't want to think about it. They don't want to overcomplicate their plan. So they just say, I'm just going to leave money to my son. Yeah, he's had some substance abuse issues, but hopefully he'll be fine by then. You can always undo these structures if you need to, but the worst case scenario is all the money that you work so hard for can just vanish, or even make someone's problems worse. Well, my kid's doing fine. In fact, my daughter's thriving. She's working at a big tech at Google, and she's making lots of money. She's doing super well. She's starting a family. I don't need to think about this. I still recommend, and our firm, Gilfix and LaPole, still recommends that you don't leave assets directly to that child who is thriving. So both Larry and Wyatt are doing fine. They have good jobs. They're living good lives. They're married. They have some kids. Both of them have parents who leave them $2 million. Both Larry and Wyatt get this $2 million. Both of them later in life endure a divorce. Both of them get into accidents later in life. As a result of what happens and how the plan was structured by their parents, when Larry passes away, that $2 million is gone. None of it's left. Zero left for the grandchildren. Wyatt, on the other hand, inherits the $2 million, still gets divorced, still has a lawsuit, but because of a difference in planning, Wyatt's children end up with $6 million from that initial bequest. And when his children pass away, his grandchildren end up with $18 million. So because of a difference in planning, one family, 2 generations later, ends up with zero. Another family ends up with $18 million. These numbers are not super exaggerated. This is the value, the time value of money. If money's invested over time, and the difference in planning versus not planning. Now, what is the difference? Larry's father left him the money directly. Over time, he commingled it with his spouse. They got divorced. A huge chunk of it was lost in a divorce settlement. Later, he gets into a car accident. He's sued. It's a really bad accident. The rest of that inheritance is gone. No protections. He lost the lawsuit. It's done. His children inherit nothing. So, of course, there's nothing left for the grandchildren. Wyatt, on the other hand, he also got divorced. He also got sued, but he had the benefit of a family protection trust. His dad did not leave money directly to him. Instead, his dad set up a family protection trust for his benefit. As a result, his inheritance was invested well and it stayed separate. So when he got divorced, this trust protected these assets from the divorce settlement. When he got sued, the trust created a barrier that the person suing him said, there's a trust. I'm not going to touch this. It was protected. So that $2 million got to grow to $4 million to $6 million. By the time he passed away, it went to his children. And that trust continued through their lives, protecting them from divorce and lawsuits. And it grew to $18 million by the time it got to his grandkids. A massive, massive difference, even though they didn't start with a huge, huge amount. What is a family protection trust? This is a way to protect assets for future generations. So if your child divorces, if you leave assets to a family protection trust, there is protection from spouses in the case of a divorce. It keeps assets separate. If your child is sued, assets in a family protection trust benefit from a high level of protection against litigants. There are very few cases of anyone successfully breaking this type of trust to get to these assets. So it's a barrier, it's a disincentive for someone suing your child. That can save millions of dollars potentially in a lawsuit. And when your child passes away, if you leave assets to a family protection trust, those assets, with some limitations, are not part of your child's estate. They are not subject to estate taxes when your child passes away. That means the money can go from your kids to your grandkids or future grandkids largely free of estate taxes, no matter what the laws, the exemption or the limits are at the time your child passes away. That can save millions of dollars. And you might think, well, this is great, but I don't want to tie my kids' hands. This is my kid who's thriving. They're great with money. They can be their own trustee. So you don't have to tie your kids' hands for them to benefit from these three very powerful protections against divorce, against lawsuits, and against future estate taxes. And these trusts last for about 100 years in California. So protections for 2 to 3 generations. And a lot of people think when they hear the term dynasty trust, they think it's only for the ultra wealthy. And yes, ultra wealthy families, ultra high net worth families have been doing this type of planning for a long, long time. But there's absolutely no reason why the rest of us, why people who only own a house in Silicon Valley should benefit from these protections. If you have any assets at all, why not protect the next generation? How do you fix this? Well, don't leave assets directly to your children if you really want to protect them. There are a lot of different powerful structures available to protect assets for or from your children while still supporting them. And this really needs to be addressed with an attorney who specializes in multi-generational estate planning. You do not need to be ultra high net worth for these to make sense. So I want you to be aware of these tools. Special needs trusts, family protection trusts, but there are a bunch of other structures that can be set up to protect future generations. Gilfix and the Paul Associates, we are true pioneers in the area of estate planning and elder law. 40 years in Palo Alto, we're very proud of that. And we've served thousands and thousands of families throughout the state of California, from San Diego up to Wairika. So we've seen it all. We've served so many different types of families from all walks of life, from just normal everyday people to Nobel Prize winners and to CEOs, but everybody across the spectrum. And I love meeting people from all walks of life, and we can provide value really to everyone. We've saved hundreds of millions of dollars, if not more, in taxes for our clients. But most importantly, our mission and our goal is to empower you and to provide extraordinary value and peace of mind. We're very proud of our place in the community and our place in the legal world. Thank you, thank you, thank you. Check out our other videos. I hope we get the chance to work with you. But regardless, I hope you got a lot out of this video. I'm Mark Gilfix. Stay safe and healthy.